Hello, good morning and welcome to the final session in our Knowledge Bank series for News on the Block, Dispensation from Consultation, hosted today by the lovely Cassandra Zanelli of Property Management Legal Services Limited. Cass has done many sessions with us before, and I'm sure she'll be able to give you lots of hints and tips to help you with this tricky topic. We will be taking questions throughout the session. So if you have any, use the Q&A button at the bottom and we'll go from there. So Cass, hello, welcome. How are you today?
Yeah, my video turned on. Good morning. How are you?
Very well, very well. Nice to see you in your sparkly jumper.
I know, it's Christmas jumper, Christmas nails as well. Look at that, the attention to detail. And Christmas earrings. Oh yeah, we're rocking the Christmas this morning.
Absolutely, very important. Well, I'm going to hand over to you now to impart all your knowledge on the subject of dispensation from consultation.
Good luck, people.
I'm sure you'll make it fun and informative.
Yeah, we try.
Yeah, the session will run till about sort of 1:45, so please do make the time and Cassandra's knowledge and just put any questions you have to her and she'll answer them throughout the session as they pop in. All right, well, over to you, Cass.
Thank you. And tweet us your pictures of you sat watching this in your Christmas jumpers. Hopefully everybody else has gone and put theirs on as well. Christmas jumper day. Yay. Fabulous. There is a set of notes as well that will come round to you after this morning's webinar. So Charlotte and the team at News on the Block will circulate these notes to you. As Charlotte says, I'm happy to take questions as we go. So rather than leaving your burning question to the end, if you want to ask me a question as you go, I've got a little question box on my screen so I can see them pop up. So please do feel free to ask any questions as we go through this morning. I assume that some of you tuned into last week's webinar where we were looking at service charges in the tribunal, so you'll have a feel for how that works anyway. So this morning, we're going to be looking at dispensation from consultation, and we're going to be focusing on a few different areas for that. So firstly, we're going to be looking at section 20 and recognising when it might be necessary to either undertake consultation or go to the tribunal and get dispensation from consultation. Then have a look at why it is that section 20 is there in the first place, what it's all about. Have a quick overview of the consultation requirements. So what you would do if you're consulting in accordance with the 2003 regs if you're in England or 2004 regs if you're in Wales. Not sure whether anybody that's watching this morning is in sunny Wales, but if you are, nod to you for the 2004 regs. We're then going to have a look at the jurisdiction of the tribunal in relation to dispensation matters, and then spend quite a bit of time looking at the well-known Supreme Court case of Daejan and Benson, because that tells us all about the approach that's going to be adopted by the tribunal in relation to dispensation, whether dispensation is binary, so whether it's yes, no, or whether there are shades of grey in between. Spoiler alert, there are shades of grey in between now. And also to have a look at the tribunal's approach in relation to prejudice. So if any of your leaseholders who are on the receiving end of a dispensation application seek to argue prejudice. And we'll talk through some of the different kind of scenarios as well, where you might be either making the application to the tribunal yourselves, or maybe involved with lawyers who are making the application on your behalf. But please feel free to put forward any questions that you might have. I've noticed, and I don't know whether you've noticed as well, that the applications for dispensation that I'm involved in have increased, so that there's more of them, certainly from my practice's point of view, knocking around than there were 12, 24 months ago. And I suspect that a bit of that is associated with the focus that we all have these days on fire safety and fire safety works. And certainly a lot of the dispensations that I'm involved in at the moment relate to fire safety. So it's either as a result of an urgent need to carry out and put into place interim measures, and there simply isn't the time to go through consultation longhand, or scenarios such as where we've started to do works and it's become obvious that the extent of the works is perhaps greater than we'd anticipated. So we need to get dispensation for those additional works. So as I say, dispensation is perhaps a little more common now than it was a couple of years ago. And the amount of people that have tuned in for this morning's webinar seems to support that. And so it's not just me, it seems to be across the industry as well. We spent a bit of time last week looking at service charges in the tribunal, and we talked, didn't we, about the various contractual restrictions on recovery of service charges. And we also talked about the statutory restrictions on the recovery of service charges. And one of the restrictions that we talked about was Section 20. And Section 20 is one of those raft of statutory restrictions. And I've put in the notes that you will get the extract from statute, and it's Section 20 of the Landlord and Tenant Act of 1985. And that says that this section, so Section 20, applies to any qualifying works. And we talk about major works, don't we? But statute actually calls them qualifying works. I had a surveyor shout at me recently because I kept calling them major works and kept reminding me that statute says qualifying works. So Section 20 applies to qualifying works or qualifying long-term agreements, and where that applies, the relevant contributions of leaseholders are limited unless the consultation requirements have either A, been complied with in relation to the works or agreement, or B, been dispensed with in relation to the works or agreement. So where we're talking about Section 20, we're dealing with two things. We're dealing with qualifying works or a qualifying long-term agreement. Qualifying works is defined by the Act, and qualifying works means works on a building or other premises. And I know that there's a lot of discussion going on at the moment about professional fees and whether professional fees are caught by Section 20, and in particular things such as your external wall surveys and stuff like that. But the Act is clear that qualifying works means works on a building or any other premises. So what that means is if you are carrying out qualifying works, so works on a building or other premises, and as a result of those works, any leaseholder is going to be asked to pay £250 or more as a service charge contribution, then those contributions are capped at £250 unless you have either complied with the consultation requirements or a tribunal has dispensed with those consultation requirements. So you have to, if you want to recover more than the £250 per leaseholder, either consult or go and get dispensation from consultation. And the same applies with a qualifying long-term agreement. And a qualifying long-term agreement, or QLTA for short, is defined by statute. And statute says that a QLTA means an agreement entered into by or on behalf of the landlord or a superior landlord for a term of more than 12 months. And if you don't consult or don't get dispensation from consultation, then for the purposes of a QLTA, you're capped at recovering £100 per leaseholder per financial period. And if I tell you, perhaps give a little bit of context around that, in the Daejan case that we're going to be looking at later, had Daejan consulted as they should have done without making errors in the consultation, then they would have been able to recover £280,000 from the lessees as service charges. Because of the failure of consultation until the Supreme Court intervened, they were capped at recovering just £1,250. So failures to consult or a failure to get dispensation can be catastrophic. If you think about the kind of costs that are being incurred at the moment, particularly in the fire safety world that we're in, you're asking for huge contributions from lessees. If you haven't consulted properly or haven't gone and got dispensation, then it's going to have a massive impact on your landlord or management company clients so far as recovery is concerned. So it's really important that you either consult properly or you go and get dispensation from consultation. And when you're making that application for dispensation, that you make it as good as it can be to ensure that your clients have the best possible chance of getting unconditional dispensation. So what is Section 20 all about? I'm getting old, and I remember pre-Supreme Court Daejan and Benson, and we all thought that Section 20 and consultation was about fluffy things like engagement and transparency and allowing leaseholders to be involved in a discussion regarding the project of works. What Daejan and Benson tells us is that the purpose of Section 20 isn't about transparency and stuff like that. It's all about reasonableness. And it's all about ensuring that leaseholders pay no more than is reasonable so far as service charges are concerned. And all that's happening with Section 20 is that we're dealing with service charges for qualifying works or under a QLTA. So the whole point of Section 20 is to hammer home this point that leaseholders pay no more than is reasonable for their service charge contributions. No questions come in yet, but please do, if you have any questions, then please do put them through. Before we embark on looking at how the tribunal are going to deal with any application for dispensation you make, I thought that it would be useful to have a quick run through of the consultation requirements. And the consultation requirements, if you're dealing with properties in England, are set out under the Service Charges Consultation Requirements England Regulations of 2003. If you are managing properties in Wales, then it is the Service Charges Consultation Requirements Wales Regulations of 2004. So different sets of regulations depending on whether you're managing properties in Wales or managing properties in England. And of course, if you're in Wales, we have the LVT, and if you're in England, we have the First Tier Tribunal Property Chamber. So different tribunals that you go to, different sets of rules for those tribunals as well. But in terms of consultation, the process is the same. So your consultation process starts with you sending a notice of intention, and the regulations prescribe what has to be contained within that notice of intention. So your notice of intention must firstly describe in general terms the works proposed to be carried out, or if it doesn't do that, then it needs to specify a place and the hours at which inspection can be undertaken. Secondly, your notice has to set out why the landlord considers it necessary to carry out those works. Thirdly, your notice has to invite nominations of contractors, so contractor nominations from lessees who think that this contractor would be able to do the job, so to invite nominations so that the landlord can try and obtain an estimate from those nominated contractors, and also invite the making in writing of any observations in relation to the works. And you need to set out where those observations have to be sent, and that they have to be made within the relevant period, and the date on which that relevant period ends. I suspect that most managing agents are using templates that do the rounds. I think there's a template on the RICS website. There's certainly one on the Leasehold Advisory Service website, and most of you probably have precedents within your organisations. The relevant period for consultation is 30 days. So you send your notice and you sit and wait 30 days, probably allowing a couple of extra days as well for postage to take effect. You will then have regard to any observations that you receive. So lessees may make observations in relation to the extent of the project of works. Is it necessary to do a whole replacement of the roof? Could you just do a patch repair? Those kind of things. And as landlord, you'll need to have regard to those observations. The next stage is to then go about and collect estimates. And I've set out in the notes, and you'll receive these notes, I won't run through it now, but where you have received nominations from lessees or from the Recognised Tenants Association, if there is one, then there's a process that you have to go through in relation to who you contact in order to get a quote. That's all set out in the notes. Please be careful if you do have nominations that are received for contractors, either from lessees directly or from an RTA, that you do follow what the regulations say in relation to approaching those contractors and obtaining estimates. you then will send your notice of estimates. I call it a notice of estimates, other people call it a statement of estimates. We used to call it a paragraph B statement a lot, but that seems to have gone out of fashion. It all means the same thing, different labels to describe the same thing. And your notice of estimates is going to set out 2 estimates of the proposed works. At least one of those people must be wholly unconnected with the landlord, and your regulations tell you what that means, whether somebody's connected or wholly unconnected. If you have had people nominated, then your statement of estimates has got to set out at least one of the estimates from a nominated contractor. And your statement of estimates will set out at least 2 estimates of the proposed works. Where you have received observations, and be careful with this because this is where people fall down. If you have received observations to stage 1, make sure in your stage 2 notice, so your notice of estimates, that you include a summary of those observations and also a summary of the landlord's response to those observations. Some people do it really carefully and kind of set out, this is the observation, this is the response, and go into a lot of detail. Some people don't go into quite so much detail, but the regulations do require a summary of the observations and a summary of the responses. Please make sure that you do that. Somebody's saying that they emailed me. Gareth, I suspect that you emailed my former email address, my new email address, because I've changed firms recently, having set up my own firm. My new email address is cassandra.zanelli@pmls.co.uk if you wanted to resend that to me. Once you've sent out your notice of estimates, you again have to wait 30 days in this relevant period of 30 days for people to make observations in relation to those estimates. And as a landlord, you have to have regard to any observations received. If you are placing the contract after all of that with somebody who has been nominated or the lowest price contractor, then you don't need to go on to the next stage. If, however, you're not going nominated or you're not going with the lowest price, then you need to serve what's called a contract notice or notice of award of contracts. All means the same thing. And essentially, within 21 days of entering into the contract, you need to send notice to all lessees and to any recognised tenants association saying why you chose to enter into that contract, because it wasn't the cheapest and it wasn't a nominated person. And also in that notice of contracts, a summary of any observations and response to them. So that's how, really quickly and briefly, you consult longhand. And it takes time, doesn't it, people? With the best will in the world, you've got at least 35 days probably with postage for each of your relevant periods. You've got time to get the estimates together. It's a 3-month plus process, isn't it, to go through consultation longhand. And sometimes there just isn't the time in which to do that. It's an emergency. You've got interim measures that you need to put in place. You can't wait. The price isn't going to be held. So because of that, statute gives you the opportunity, the option of going to the tribunal and saying to the tribunal, please, tribunal, grant us dispensation from consultation. And it's section 20ZA of the Landlord and Tenant Act that deals with that. Before we look at the jurisdiction of the tribunal, there's a couple of questions that have come through, so I will deal with those really quickly, if I may. Eva has asked the 30 days that I talk about in terms of the relevant period, whether that's 30 working days or 30 calendar days. It's 30 calendar days, it's not working days. Hopefully that answers your question there. What most people do as well, Eva, is that although the legislation talks about 30 days as the relevant period, is that they allow a few days postage as well, because there's case law that says that the 30 days starts when the notice does the work required of it, i.e. that it lands on somebody's doormat. So I would go 30 plus a couple. I think the general practice is about 35. Melissa says £250 and £100 was put in place back in October 2003. Yeah. Do you think there is a likelihood of this increasing? Do you know what? It's talked about a lot. It really is. Every conference that I go to, it's talked about that there may be an increase to the 250 quid limit and the 100 quid limit. Because particularly for the 250 quid limit, I feel your pain that if you manage a small block with not very many flats, that you are going to get to your limit very quickly and be consulting quite a bit. All I can say is that it's talked about quite a lot and the promises aren't being delivered on. So is there a likelihood? I don't know. Should it be increased? Yeah, it really should. Alan says, how is give regard interpreted by the courts? There's a different approach, Alan, where you are dealing with a discretion to improve, so works of improvements, and an obligation to repair, so works of repair. And the tribunals recognise that there is that distinction between an obligation to repair and a discretion to improve. So if your works are repair, then it's a narrower way that the observations can, or the observations are narrower that leaseholders make. If it's improvements, then the ability to make observations and relevant observations is wider. So with works of improvement, you will be obliged to look at things like the financial impact of these works on leaseholders. Whereas if it's works of repair, then the financial impact isn't something that you would necessarily have regard to. There's a case, it's a case that's a couple of years old now, it's Waller and Hounslow, that talk about that distinction between works of repair and works of improvement, and the difference that there is between an obligation to repair and a discretion to improve, and the approach that landlords should take if they're dealing with improvements versus repairs. The regard that you have should be wider because of improvements rather than repairs, but take a look at that if you are dealing with those kind of things. Gareth says that he sourced 3 quotes for works, but if we only source 1 quote, would that weaken our position when we sent in a submission to the FTT? So you're applying for dispensation, but instead of going for dispensation with 2 or 3 quotes, you're going for dispensation with 1 quote. If you can only get 1 quote, then so be it, that's what it is. If you can get more quotes to show the tribunal, then they like to see those. And if, as I'll encourage you to do later, you're making a 27A application at the same time as a 20ZA, then that will strengthen your position so far as the reasonableness of the cost is concerned. Just looking at some of the, oh, David's asking the same question. Sorry, guys, I'm trying to multitask and failing miserably. Julie says, you referred to observations made on estimates. If you send out a 3rd letter, which is the award of contracts, do you have to advise all leaseholders of observations made to the quotations letter? In a word, yes. So if you aren't going for the cheapest or going for the nominated, then yes, when you send your award of contracts letter or contracts notice, whatever you want to call it, you have to put in that a summary of the observations you received to your statement of estimates and a summary of your responses to them. Chris is asking about superior landlords. Chris, I will come back to that in a moment. Charles raises a question about the word estimates and whether it's fluid. Is it not better that contractors are required to provide a quotation? Estimates is the language that's used in statute, Charles, which is why I adopt that language. but I agree with the point that you're raising there regarding quoting on a like-for-like basis. So I suspect that what you do when you're undertaking any consultation exercise is to have a specification prepared and to get your contractors to quote against that specification. That way it is like-for-like and you're comparing apples and apples. Sean says, which case were you referring to with regards to the repair improvement distinction? It's Waller and Hounslow. Waller is W-A-A-L-E-R, so W-A-A-L-E-R, and versus Hounslow, London Borough Council. Fabulous. Keep your questions coming through. So jurisdiction of the tribunal is section 20ZA, and tribunal, we know from last week, is a creature of statute. Love that phrase. And the tribunal derives its jurisdiction from statute because of that. So it can only do what statute tells it can do. And where we're dealing with consultation, statute tells the tribunal that where an application is made to it for a determination to dispense with all or any of the consultation requirements, that the tribunal may make that determination, so may dispense with the consultation requirements if it is satisfied that it's reasonable to dispense with the consultation requirements. So it's a reasonable test here that the tribunal apply. Is it reasonable for us to dispense with some or all of the consultation requirements? So an application might be made to dispense with elements of the consultation requirements, or an application might be made to dispense with all of the consultation requirements. And there are, I suppose, different times and different triggers for making this kind of application to the tribunal. You could make the application before the works have been started, before the contract's even been signed. So it's before anything's happened, application made to the tribunal to dispense with the consultation requirements. Might be an emergency. You can apply to dispense with the consultation requirements after the works have been carried out. It might be that you've had a go at consultation and it didn't quite go right, or you got it wrong for whatever reason. After the event, you can apply to the tribunal for dispensation from probably some of the consultation requirements. You might have got your stage 1 right, but you might have just messed up on stage 2. So you can apply after the event for dispensation to cover and correct what you got wrong. And this happens quite a bit, you can make an application for dispensation if it would be difficult or impossible to comply with the consultation requirements. And that comes up a bit. I've had quite a few of these. I don't know quite why they land on my desk, where we can't comply with stage 2. The example that I tend to give is nice blocks where we've got crystal windows, and the local planning authority says, yeah, you can replace your windows, but you need to replace them with crystal. We're not going to accept anything else other than crystal. Well, that being the case, I can't serve my notice of estimates because I can only get an estimate from one person. In those circumstances, I apply to the tribunal for dispensation because I can't carry out consultation in accordance with the 2004 regs. So it's either before you do the works, after you do the works, or if you're not able to consult for whatever reason. And the example that I've just given you is one that I come across quite a bit, where local planning won't accept anything other than crystal. What kind of approach then is the tribunal going to take in relation to dispensation? Because pre-2003, so pre-Daejan and Benson, we thought that it was all about transparency, and we thought that dispensation would only ever be given for minor breaches. So if you got the date slightly wrong by a day or two, then you might get dispensation. Anything other than that, you were never going to get it until Supreme Court, Daejan and Benson. The facts of Daejan and Benson, very briefly, are that we're dealing with a block of flats, it's a mixed-use block out in Muswell Hill, where you have some commercial on the ground floor, so a few shops, and then there are 7 flats on the upper floors 5 of which are let on a long lease. Standard lease where the leaseholder pays service charge, landlord repairs, maintains, etc. And the landlord in Daejan wants to do some major works, and those major works are going to cost around, depending on which estimate you go for, anywhere between 420k and 450k. So quite a decent project of works, and 280k of that is going to come from these 5 lessees who each have the lease of one of these flats. And Daejan go to the tribunal, LVT as it was at the time, and LVT found that Daejan had failed to comply with the consultation requirements because the notice of estimates didn't contain a summary of observations. Going back to one of the questions that was asked, this is why it's so important to make sure your notices contain the summaries. And the estimates themselves weren't available for inspection. Daejan applied for dispensation, as you would expect. Without dispensation, Daejan would have been able to recover just £1,250 out of the £280,000 that it would otherwise have been able to recover had it consulted properly. LVT say no, can't have dispensation. SOS. It wound its way up through the courts, and as it went up on appeal, up a tribunal, they said no. Court of Appeal said no, and we expected the Supreme Court to say no as well, but Supreme Court said yes. Supreme Court said that Daejan could have dispensation from consultation, and the Supreme Court looked at 3 things, and these 3 things are important when you guys are dealing with dispensation, whether you're making the applications yourself or whether you have got lawyers involved making the applications on your behalf, because these are the things the tribunal are going to be looking for. So you need to present these to the tribunal or get your lawyers to present them to the tribunal, and they'll be asking for information from you. So Daejan looked at 3 things. It looked at the approach to be adopted by the tribunal on any application for dispensation. It looked at whether the decision itself was binary, so yes, no, or whether the tribunal could grant dispensation on terms. And it also looked at the approach that the tribunal should adopt when dealing with prejudice, because the argument that's raised by a lot of leaseholders is that they have been prejudiced as a result of a failure to comply with the consultation requirements. So let's take each of those in turn. And firstly, the approach to be adopted. So what approach are your tribunals going to take? Well, statute, section 20ZA, gives very little guidance to a tribunal how it should be exercising its discretion to dispense. Save that, the tribunal must be satisfied that it's reasonable to dispense with the consultation requirements. Doesn't really help that much. And if you think section 19 is all about ensuring that leaseholders are not required to pay for unnecessary services or services that are of a shoddy standard, and that they pay no more than they should for those services. And that's really what reasonableness is all about. And section 20 and section 20ZA is an extension of that. It's a reinforcement of that. So it's a reinforcement of reasonableness and this principle of reasonableness, and it's there to give practical effect to that principle of reasonableness. So what it's all about and what the tribunal should be looking at is ensuring that leaseholders are protected, firstly, from paying for inappropriate works, and secondly, from paying more than would be appropriate for those works. So it's all about making sure that the leaseholders don't pay more than they should for works. And that's what dispensation is there for. It's that protection, and it's that extension of reasonableness and giving practical effect to reasonableness. And you'll see in the notes that you get that I've quoted a section from the Daejan decision. And what I've said in the notes is that because of this, the focus of the tribunal should be the extent, if any, to which the leaseholders have been prejudiced. And here prejudice talked about a lot where we're dealing with dispensation. So it's the extent to which the leaseholders have been prejudiced by the failure of the landlord to comply with the consultation requirements. And you'll see when lawyers are submitting dispensation applications and when they're making submissions to the tribunal, they will talk a lot anyway, I could have put a full stop there, but they will talk a lot about the fact the leaseholders haven't been prejudiced. They haven't shown any relevant prejudice. This is why. And the quotation that I put in the notes that you receive says, in a case where it was common ground that the extent, quality and cost of the works were in no way affected by the landlord's failure to comply with the requirements, I find it hard to see why dispensation should not be granted, at least in the absence of some very good reason. In such a case, the tenants would be in precisely the position the legislation intended them to be, i.e., as if the requirements had been complied with. So that's what you need to be looking at. Has the position of the leaseholders been affected in any way by not consulting in accordance with the regs and applying for dispensation instead? Has the extent of the works been affected? Has the quality of the works been affected? Has the cost of the works been affected? I suspect the answer to those in most cases is no. And if the answer is no, then tell the tribunal that. Make sure the tribunal are aware of that in the documentation you're submitting, because that's the focus. The focus is, has the position of the leaseholders changed because you haven't consulted, because you're asking the tribunal to dispense with consultation? Just pause there and see if there are any questions that I can answer at that point before we start looking at whether dispensation is binary. As I say, Chris, I'll come on to yours in a bit. Leanne, I will come on to question about cladding. I suspected that there would be a question about cladding. And Beth says, is there ever a reason under law to dispense with dispensation altogether or to dispense in retrospect? Law's clear that if you intend to put through the service charges more than 250 quid a leaseholder, then you either have to dispense or go and get have to consult or go and get dispensation from consultation. That's if you intend to put the cash through the service charges. If you've got a 2-unit block, then it may be that you look at other ways of recovering the costs. It doesn't always have to wash through the service charges. If we've got time at the end, I will pick up in relation to that. Somebody says, if we've raised a dispensation, what if the leaseholders have raised objections? We'll look at that in a moment. Okay. Please do keep your questions coming through. The second thing that the tribunal are going to look at when they're dealing with dispensation, because of what Daejan and Benson tells us, is whether or not dispensation is binary. And by binary, I mean, is it yes or no? Or are there shades of grey? Prior to Daejan and Benson, it was binary. You either got dispensation or you didn't. And you would only generally get dispensation if it was a minor breach. Anything more than that, and you wouldn't get dispensation. The consequences of that financially were catastrophic, as we've talked about. So the Supreme Court in Daejan looked at whether dispensation was actually binary and whether we'd been getting it right or wrong all of these years. And the tribunal said that dispensation isn't binary, that the tribunal have power to grant dispensation on such terms as it thinks fit. The example that is given in Daejan, and I'm sure that you can think of lots of examples as well, is an emergency situation. And in an emergency situation, a landlord could apply for dispensation and the tribunal could grant dispensation on terms. And examples of those terms that are given in Daejan would require the landlord firstly to convene a meeting with all leaseholders at short notice in order to explain and discuss the works. And another condition that might be attached to that kind of dispensation would be for the landlord to serve a stage 1 or stage 2 notice, but instead of the 30-day usual period under the regulations, that it would allow 5 days instead. So you can be quite creative when you're going to the tribunal and asking for dispensation from consultation. You can say to them, can you please give me dispensation? And these are the kind of conditions that I suggest. I had one last week where I was applying for dispensation and we suggested a raft of conditions. We needed dispensation, we needed it quickly, but we recognised that there were certain conditions that we could offer to the tribunal in order to persuade them that dispensation was the way to go. So think about it when you're dealing with dispensation applications, whether you can offer conditions that make it more attractive to the tribunal to give you dispensation. Chances are you're going to get dispensation. It's simply a case of whether you get dispensation on terms, whether there are any conditions attached to it. If you can control what those conditions are, then all the better. As I say, the tribunal have that power to impose conditions. Daejan came out in 2013 and we'd not really had much by way of case law on the kind of conditions that the tribunal will impose. There was an upper tribunal case from the summer that dealt with conditional dispensation. So if that is something you're interested in, let me know and I'll share that case with you. One of the conditions that you may well get, and I flag this with you, is a condition in relation to costs. So it may be that you get your dispensation from consultation, but that dispensation is conditional on you paying the lessee's reasonable costs in connection with the application. Really depends on the circumstances and what's given rise to the application being made in the first place. Just have a look and see whether there are any questions in relation to that. Alan's asking about company law to override section 20. As I say, Alan, if I have time at the end, then we'll look at whether there are other ways to skin a cat. Sorry if you heard that. My phone's ringing. The third thing that the tribunal will look at, and this is an important thing as well, is the approach to prejudice. And this is because generally where you apply for dispensation, there's a bit of a bun fight going on about whether lessees have been prejudiced. So where there has been a failure on the part of the landlord to comply with the requirements, there is often that underlying dispute as to whether and to what extent leaseholders would suffer and be caused prejudice if unconditional dispensation was granted. Now, it's important here to remember that the factual burden of proving prejudice, of identifying relevant prejudice, sits with the leaseholders. So the leaseholders have to satisfy the factual burden that rests with them of demonstrating relevant prejudice. The tribunals are sympathetic to leaseholders on this point, and indeed Daejan encourages tribunals to be sympathetic. What the tribunal is doing here essentially is a bit of a reconstruction exercise. It's looking at what would have happened had consultation been undertaken in accordance with the regulations. What would the leaseholders have done differently? What would they have said? What would they have done that led to a different outcome? That's what the prejudice is here. The leaseholder has to argue, if you'd have consulted, I'd have told you that you could have done a patch repair rather than doing a full repair. You'd have listened to me, would have spent 20 grand instead of 200 grand or something to that effect. And if the leaseholder is able to show a credible case for prejudice, remembering that the factual burden lies with them, then it's going to be up to the landlord to rebut that. So when you're dealing with these kind of applications, whether you're dealing with them yourself or whether you've got lawyers, in your submissions to the tribunal, you're going to be talking about this and you're going to be saying nothing would have been different. The outcome would have been exactly the same had we gone through this 3-month process. We would still be in the same position. The leaseholders would still be in the same position. They have not suffered prejudice as a result of us bringing this application for dispensation. Nothing would have been changed. Nothing would be different. They're the kind of things that you need to talk about when you're looking at dispensation and when you're putting all of the stuff together for your lawyers as well. Anybody got any questions in relation to dispensation? Keep them coming through if you have. Any questions in relation to the approach the tribunal will take? So they're going to be looking at prejudice, they're going to be looking at the outcome, they're going to be wanting to make sure that these costs are reasonable and that the extent, quality and cost of the works hasn't been affected or won't be affected by their grant of dispensation, and also to have a look and see whether any conditions could or should be attached to that grant of dispensation. When I'm dealing with dispensation applications, particularly if it's before the event rather than after the event where it's gone slightly awry, then there is an interplay between dispensation applications and applications under Section 27A, which is an application for determination on liability to pay service charges. And sometimes dispensation applications come about because you faced a service charge application and it's become apparent that you've done major works and you're not consulted, so we need to go and get dispensation. Or consultation has its flaws. None of us are perfect. Where I'm finding that I'm using Section 27A together with 20ZA is where I'm applying for dispensation before the contract has been entered into, so before the works have been undertaken. It's where if I'm with my client, it's my client, isn't it? Where my client might be wanting to undertake a project of works that's going to cost £1 million. They haven't got time to consult. These works are an emergency, they need to be done. And at the same time as applying for dispensation, they'll apply for a determination on liability to pay. So they get both done together at the same time. They get their dispensation, so know that in principle they can recover the costs, but also they get their service charge determination, tribunal then telling them that they can recover those costs, that those costs are recoverable under the lease, and that it's reasonable to incur costs in that kind of way. So if you are thinking about making dispensation applications before you do the works, then have a think about whether it's appropriate to tag on to that an application for determination on service charges, so a preemptive application. It's not going to be a huge amount more work if you're doing them both together, or if your lawyers are doing them both together. I think it's useful. It's that sleep at night test. In terms of what will happen when you make the application, so your application will be made to the tribunal. You as landlord will be applicant. There's a specific form for either LVT or FTT, depending where you are in the country. And there are application fees payable, again, vary depending where you are. You as landlord will be applicant, and all lessees will be respondents to that application. And the application will be circulated to lessees, and unless it's an emergency, so unless you need it turning around within a couple of days, then the lessees will be given an opportunity to participate in the proceedings, and they'll be given an opportunity to participate and support the application for dispensation, so to say that they agree with it. And they'll also be given an opportunity to file any objections to that application. And this is going to be in terms of prejudice and the like. So you make the application, that's circulated to lessees. The tribunal might ask you to do that circulation on their behalf. And then the lessees will be given the opportunity to participate and either support or object. And they'll need to file evidence setting out why they object, what their prejudice is, because that factual burden sits with the lessees. You will probably, in accordance with the directions, be given an opportunity to respond to that. So to be able to file evidence rebutting that suggestion of prejudice. In terms of determination, if this is something that is being objected to, then I suspect you're going to have it disposed of at a hearing. I would certainly be inclined to say, if it was me dealing with it, we should be at a hearing if there are objections, particularly where we're dealing with issues of prejudice. I'd want to be there making those strong representations to the tribunal. If there are no objections, then it might be something that I would trust the tribunal to deal with on the papers. It's a judgment call in relation to each case judged on its merits. And the tribunal may give you a very quick decision if it's an emergency situation. I've had very quick decisions from tribunals in those kind of circumstances. Usually you're going to get the decision in writing a couple of weeks, if not more, after the hearing. It depends on the nature of the application that you have made. Let's have a look at the questions that have come through. I'll tell you what, let's pick, oh, Charlotte's appeared on screen.
Hi, Cass. We're nearly running to the end of your session. So if there's any final questions you want to get through.
Okay. Can I pick up on the question that a couple of people have asked, and it's about whether we have to put everything through the service charges. I think that the default position of most of us is that when we're incurring costs for a block, we go, oh, well, let's put that through the service charges because we have a lease, and that's generally how we recover costs on a block. That's not the only way of doing it. If you recover costs via the service charge, then this whole raft of protections under sections 18 to 30 apply, section 20 being one of those protections. There are other ways of recovering costs. You can, if you have a 3-unit block where all lessees own a share of the freehold, use your company, if they own it as a company, as a vehicle to recover the costs for the £10,000 project of works that you want to do. Don't recover it as a service charge, recover it using your company as a vehicle to do that. It's very easy for me to sit here and say it, and to do it like that, not quite as easy in practice because there's different factors to consider, but there is an ability or a way around section 20 and a way around service charges. It's to use the company as a vehicle to do that. Just looking if there's any
quite
more.
a lot of questions today, so that's really good. I hope everyone's enjoyed the session. I'm sure everyone's found it very useful. And thank you so much for taking time to host it today. We'll send the notes out for the session when you get them across to us, Cass. And thank you for joining us, and we will look forward to seeing you in the new year. Hopefully everyone's feeling jolly and hopeful with the vaccine on its way, and fingers crossed.
Yeah, absolutely. Thank you very much for inviting me along last week and this week as well. It's been great. Thank you.
Oh no, it's a pleasure. Thank you very much, everybody. Thank you.
Thanks everyone. Merry Christmas.
Happy Christmas.